Ladies and gentlemen, welcome to the Kentucky Court Interpreter Orientation for new interpreters. We're super excited to be here with you. My name is Joshua Elliott. I am the Executive Officer of Kentucky's Office of Language Access. I am privileged to be presenting today with my partner, Aymara Liste Gonzalez. She is the Operations Manager of the Office of Language Access, and we're super excited to be here today. We'll tell you a little bit more about ourselves in just a moment. This is the first time that we have ever offered orientations in this way. Normally we do orientations, of course, live. You guys would come see us in Frankfurt. We would present in person, and it's a little bit different. Of course, COVID has changed things, and so we're using a new format this time around. We're calling it Orientation on Demand. So we are recording a series of videos, and we'll make them available to anyone interested in going through our certification process. The first step of that process will be to watch all the videos, and there's going to be quite a few, as we'll talk about in a moment. So we're super excited. Please bear with us because this is a new thing for us. It's a new activity for us. We envision there being some hiccups along the way, so please show us grace as we work through this the first time. But I believe that if you hang in there and if you watch our videos, you participate fully, you will get the information that you need to ultimately become a court interpreter in the state of Kentucky. Super excited here. So let's move forward just a little bit. And I think the first thing that we need to do would be some introductions. And let me tell you a little more about myself, and then I want to turn it over to Aymara so that she can tell you a little bit more about her background as well. So as mentioned, my name is Joshua Elliott, and I am currently the Executive Officer of the Office of Language Access. I have been with the state total for around 12 years. And throughout that time, I've done many different things within the interpreting department. So I started off as a staff interpreter in Jefferson County, which is Louisville. And then I became division supervisor of the Spanish interpreters. And then I became state manager. And so I managed our statewide program. And then actually I left. I left the state for close to 2 years, a good year and a half or so, and I took a position as the supervisory staff interpreter for the federal courts of the Southern District of Florida, and specifically that's Miami, Florida. So my family and I, we moved down there, and I got some fantastic experience, but man, did we miss Kentucky. And I feel very fortunate to be back here and to be home and to be back now as the executive officer, really overseeing the work that we do, doing really high-level projects, just trying to make things better in our state in terms of language access. I have a master's degree in Spanish with an emphasis in Spanish linguistics. I was a Border Patrol agent for a while, and so that experience certainly has helped in my line of work. I am state certified for court, and I'm also federally certified for court, and so I do quite a bit of work both at the state and federal level. Of course, I've taught quite a bit as well. I love to teach, and one of my favorite things actually is to do one of these orientations like this because I just love interacting with our students, with our interpreters. Lastly, but certainly not least, I would say that I'm married to the love of my life. I've got 4 incredible kids that keep me busy. So life is great, man. That's really my story, and I'm really just happy to be here. Feel very fortunate to be here and to present to you. Without further ado, let me turn it over to my incredible co-presenter, Aymara Liste Gonzalez. Aymara, say hello to the kids. Introduce yourself.
Hi, everybody. Thank you, Joshua. Like Joshua said, I am the operations manager. I came to Kentucky. It's going to be 3 years in April as manager and now operations manager. I was before that a certified court interpreter and staff interpreter in the Ninth Circuit in Florida, which encompasses the counties of Orange and Osceola. And I'm also a federally certified interpreter. This is my second online orientation. We did one, was it December, Joshua?
So.
I think it
I
was
think
in
so.
December. We did one. I think Joshua and one of our colleagues had already done another one online, but it's a very interesting process. We hope you enjoy it. Like I said, I'm a federally certified interpreter, state certified interpreter, admitted in Florida and Kentucky. And before that, I practiced law for a few years in Florida as well.
Thank you so much. We are very fortunate to have Imarda, to have her expertise on many different levels in the things that she's doing for our team. So I can't wait to present with her. I can't wait for you guys to just benefit from the experience that she has. I really think that we have some valuable information that we can share. So it's going to be a good time. Normally at this time in our orientation, we would do some introductions from you guys as well. We would hear from you. If you are watching this video, that means that you've already contacted us. We sort of know who you are. We've already met you on some level anyway. We've said hello, and we're sending you this because you've indicated that you are interested in pursuing certification. So hopefully we've already sort of met. If that's not the case, please reach out to us. We're going to give you our email addresses at the end of today's presentation. And please reach out to us, say hello if there's something that we need to know about you. One of the best parts of this job is just getting to know people. And I'm sorry that we're not able to do that right now, but please don't be a stranger. So let's move forward. We're going to talk a little bit about the agenda in this orientation in general. So this isn't necessarily restricted to today. This is covering everything that we will ultimately present over the course of several videos. And so today's video will focus on really numbers 1 and 2 here. We're doing introductions. We're going to establish what our goals and objectives are, and then we're going to cover really an overview of the Kentucky Judicial System. But throughout this series of videos, you will see several different things related to important topics that we deal with every day in the field of court interpreting. And so those things are here. This is essentially what we will cover in these videos. So let's go through it. So as we talked about today, the introductions, this is our agenda. We're going to set some goals and objectives. Overview of Kentucky Judicial System. Imarda and I will take you through several slides designed to help you understand just the setting in which interpreters work, and we'll try to give you some different perspectives of that. We'll then go through something in the next video called Court Interpreting 101. It's sort of the nuts and bolts of court interpreting. How's it work? What is it? Let's define it. Where do you stand? That kind of thing. What are the modes of interpreting? Then we'll cover administrative procedures and the Kentucky certification process. Many of you, of course, are wondering, well, this is all great, Joshua, but how do I become certified? How do I actually take the test? When do I sign up? We'll talk about that as well. That'll be a separate video. We'll also talk a little bit about bilingualism and skills needed to be successful as a court interpreter. Maybe you're thinking, well, yeah, I'd love to be certified, but do I have what it takes? Well, we're going to talk about some of the traits that are common among successful interpreters. We'll talk about modes of interpreting, and we'll do some skills building. It'll look a little different since we're doing this orientation on demand format. We won't be able to interact with you, but we're going to definitely cover the 3 modes and give you some materials for you to work on your own with. And I think it'll be very beneficial that way. And then lastly, we'll spend quite a bit of time talking about the role of the interpreter. And of course, here we're really talking about ethics, professional conduct, protocol, and procedures. We're sort of going to talk about that indirectly throughout the videos, and then we will address it very directly in that last video that's sort of a wrap up of everything that we do. So the idea is for you to receive several videos. I want you to go through them in order, number 1 through number 7, right? Or however we end up numbering those. And at the end of it, I want you to reach out to us with questions. And you can, of course, do that after every presentation as well. It's an important part of this process that you reach out to us to clarify any doubts that may arise as we're presenting to you. So in a nutshell, that's what we're going to do. That's what we normally do on site. And so we're transitioning to this on-site methodology. Let's talk a little bit more about the things that we will cover as we're presenting, because I just want to make sure that we're setting a good foundation up front. I want you to come into this with realistic expectations, because we can't cover it all, right? So let's talk a little bit about what we will do, and then Imarda's going to talk to you a little bit about what we won't do. Okay, so what we will do: overview of the most important concepts related to the field of court interpreting. For example, required skills, the general modes of interpreting, bilingualism, things that you just got to know to get into this field, or things that will help you determine whether or not you want to go forward with this career choice. It's not for everyone, and so part of this orientation is just helping you determine, hey, is this for me? Do I currently have the skills to do this? If I don't, can I get them? Or maybe now I understand that this is really not what I thought it was, and it's not for me, and that's totally okay. No harm if you ultimately decide not to go forward. That's why we really take so much time during these orientations. We'll also have a discussion of general interpreting techniques. Of course, we're going to tell you how to do it and where to stand and how it works, and the good, the bad, and the ugly of court interpreting. We're trying to get into those nuts and bolts kind of thing. We will have an in-depth discussion of interpreter ethics, protocols, and procedures as related to court interpreting. We're going to talk about that a lot. As mentioned before, we'll specifically talk about that in the very last video of the series, but we'll sort of mention that indirectly throughout. Everything that we do really is governed by interpreter ethics. So it's going to be important for you to understand that very early and see how that really applies to the varying work that we do. We'll also do some basic skills building methodology and techniques. It's going to look a little different, as I mentioned before, but definitely our intent is to expose you to the 3 modes of interpreting. I'm not going to tell you what they are now, but there are 3. Do you know them? We'll see. We're going to show you how to practice. We're going to give you materials to practice with, which will be given to you in a separate file, and you guys will be able to access those and work on those materials on your own and then get back to us with questions. So definitely that's a part of what we intend to do. We'll also discuss state and federal certification exams. Of course, you're talking to the state program for Kentucky, so we're mostly interested in that state exam, but we're going to briefly cover the federal exam. I want you guys to be aware of what that is, what it looks like. We'll discuss possible resources to assist you throughout your career, maybe resources for continued development after this orientation. It's going to be very, very important. We're, of course, going to have an overview of the Kentucky Judicial System. We'll get to that in just a few minutes. I think that's really important. Sometimes we underestimate how important that knowledge is. You're going to be working in our courts every day. It's important for you to understand how information flows through our judicial system, and specifically maybe how you interact with that judicial system. What's your role in that process? What are the rules that you have to play by when you're in court? We'll try to highlight that just a little bit. And of course, we're going to have lots of fun. Marta and I, we're a barrel of monkeys. I'm telling you, it's going to be fantastic. There's usually a lot of interaction in these types of presentations. Obviously going to be a little bit less, but I do want you guys to enjoy this. We're going to try to keep things light. We fully expect that there are going to be some mistakes. We're not going to say the right thing sometimes. Maybe there are technical issues. Just roll with it, okay? Help us along the way. We would appreciate your grace, and we will try to keep things lighthearted as well as we go. So we do expect to have a good time. Let's talk a little bit about what we will not do. I'm going to turn it over to Marta, and she's going to take us through this a little bit. Marta, take it away.
Certainly. Thank you, Joshua. Yes, there are things that we cannot do. This is normally a 2-day process, one to go over generalities and the other to do a little bit of practice and talk about ethics, like Joshua said before. But as you can imagine, we cannot in 2 days take on the task of conducting language specific training, because under normal circumstances, we have generally the majority of our people that come to the orientation Spanish speakers who are interested in being Spanish English interpreters. But we also have a lot of other speakers. Kentucky is a very diverse community. So we have people that speak many different languages. We couldn't possibly in 2 days do a language specific training, and that's not what the orientation is for in any event. Discuss the interpretation of legal technical terms for the same reason. I could only tell you how something is said in Spanish, and even then we would have many correct ways of saying it in different places. Every situation that you have encountered in court, I like to say about this, Joshua, that within 6 months of practicing as an interpreter in Orlando, I already had enough anecdotes to write a booklet. So I'm sure that with 12 years or so of experience, you could write a couple of them. We couldn't possibly tell you everything that could go right or everything that could go wrong in just a couple of days. We couldn't practice for the oral exams. This is not a skills building workshop. Practicing takes a lot of time. It is practice. There is a saying in the law that the law is a jealous mistress, and language indeed is, I would say, an even more jealous mistress, because language is such a living thing. Different generations have different ways of saying things. The reality of the country that you are in also changes and influences language. So we couldn't possibly build that and prepare you extensively for the exam. And that goes also with the last point of turning you into capable interpreters. Without a doubt, it takes a lot of blood, sweat, and tears. Not something that can be done in 2 days. Now, there are some of you that are already certified interpreters in other states, and what you're looking for is reciprocity. So you are required to attend this orientation or watch it in this specific situation online, so that you get familiar with how we do things in Kentucky. A lot of these may be already familiar. You may be familiar with it, but for those who are new at this, know that it is not something that, even if you have a knack for it, it doesn't just happen overnight. It does take a lot of effort.
So let's talk about a few basic guidelines in terms of how this is going to work. Normally, when we're on site, of course, we're in person, we give you some specific guidelines to follow because we're all there physically. I think the same is true in terms of doing this on demand, doing this with pre-recorded videos. There's just a few things we want you to keep in mind as we go through this process. So there are several videos, and it's difficult to pay attention. I really want to encourage you to pay attention to all presentations, and remember as well that it's okay to pause the recording and come back later. One of the advantages that we have is that, hey, it's on your time. Take your time, really digest the information that you're receiving, and it's all right to pause, to step away a few minutes, go take a break, go eat lunch. Usually we talk about specific breaks. We talk about lunchtime. Well, you can do that on your own. Don't be afraid to do that. Pause the recording, come back. Also, feel free to rewind, watch something again. That's okay, but pay attention to all presentations. Also, I would say feel free to take notes throughout each presentation to remember important information. We are going to cover lots of information. This orientation is really just packed full of guidance and information and instructions. It's a little overwhelming at first. It's fine to take notes. You may be better served just by watching and by listening. That's okay too. Everybody's different. But certainly if you wanted to have a notebook and start writing down things for every presentation, for every video, it might be very helpful to do so. Also, don't forget to access the supplemental materials provided to you by our office. So if you are receiving or have received these videos, we have also sent you a link to supplemental information materials that we're giving you access to. They include things that will assist you with each of these presentations, additional information, additional documentation. There's some really great ethical information in there, and of course there's skills building materials in there. And so along the way we may mention to you, hey, this is in supplemental materials, access this in the supplemental folder we gave you. So that's what we're talking about. And again, if you've received these videos, you should have also received a link that will lead you to an online folder with those materials. Don't forget to do that. That's really important. Lastly, follow up with me, follow up with Imarta to clarify any questions that may arise. At the end of each video, we will give you our email addresses. And we really want to encourage you just to reach out to us and ask questions. Normally, if we were in person, we would interact with you a lot. We would take questions along the way. That's just part of the process. So we expect that. Please know that you're not bothering us. If you send an email to us, it's not a bother for us to answer you. Just give us a little bit time to respond because, we're out and about, we're in the field, and we both have things we're doing, but we will get back to you, and we'll make sure you have the right information, the information you need to feel comfortable as a court interpreter. All right. So that's important stuff. Marty, you want to add anything to our basic guidelines?
No, but on that point, do feel free to send us emails. And like Joshua said, give us time because we're both still interpreting, not only running the departments. So you may not necessarily get an answer from us within 24 hours, but be assured that when we get those emails, we will answer them to the best of our ability and give you the best possible guidance we can regarding the process, okay?
And that was a great point that I might have just mentioned. That it's one of my favorite things about our department. Almost everyone that works directly for us in a staff capacity is also an interpreter, right? And so we all do different administrative things. I'm the executive officer, so I sort of focus on these big projects. Marta is the operations manager, so she has a very specific role out in the field. But we also interpret. That's just a bottom line requirement. All of our staff interpreters, they manage different things in our department, but they're also interpreting. We actually only have two administrative workers, administrative assistants who keep us running behind the scenes. Those are the only two out of a department of 13, I believe it is, that don't actually interpret directly. So that's an important clarification. in my heart of hearts, I'm an interpreter. I know that Marta feels the same way. So you're getting information not from, a stuffy old administrative guy who pushes paper all day, right? You're getting it from an interpreter who's actively practicing. The same for Marta. So we're really excited about that. I love that about our department, actually. So let's do this. We're going to rock it out now. You may hear me say that a few times along the way, just going to rock it out. In court interpreting, you just got to rock it out sometimes. So we're going to talk a little bit about the judicial process, the judicial system in Kentucky. And what we're going to do, Marta and I are going to take turns presenting. Every few slides, we'll switch back and forth. And, I put on here our names with some of our degrees behind it. And I think this is important to highlight up front. So if you see mine, I have a master's of arts in Spanish. My focus is always linguistics. I love sociolinguistics. I love pragmatic linguistics, right? Just really hands-on pragmatic kind of language usage. And the FCCI, what that means is federally certified court interpreter. So, as I said, in my heart of hearts, I'm a court interpreter. I'm not an attorney. There's no JD behind my name. So it's important as I talk about law that you understand the perspective that I'm giving relates more to the role of the interpreter, how we interact with the judicial system along the way, what you may actually expect working in that field, interacting with court professionals, what that looks like from the interpreter's perspective. Marta also has that same experience that I'm talking about. So she'll give you that interpreter's perspective, but we're extremely fortunate because she does have her JD, which is Juris Doctorate. She is an attorney. And so you really get both perspectives in this presentation. And I think you're going to really benefit a lot from the information that we can give you. So again, as we approach this, think about the information that we'll provide from the perspective of the interpreter. Our goal here is not to make you a legal expert. You're not going to take a test on how the judicial system works per se, but I want you to understand how information flows, the types of things you may interpret, and specifically the role that the interpreter plays in these different working parts, different moving parts of our judicial system. And Marta's here to answer some technical questions as well, give us a little bit more background. So without further ado, let's go forward. What we're going to start with actually is a picture of a courtroom. There you can see it. This is just a random courtroom. I'm not sure if this is a Kentucky courtroom or not. Maybe we found this on the internet. I don't know. But this is a general sort of an old school kind of courtroom. And, if I were taking a show of hands right now and I asked you guys, okay, raise your hand if you've never been in the courtroom, a surprising amount of you would actually raise your hand, right? I think most people don't necessarily visit courtrooms unless something really bad happens. Now, on the flip side, I hope you haven't been in a courtroom as a defendant, right? Maybe you got a traffic ticket. That's okay. All right. Hopefully nothing more serious than that. There's a background check along the way, by the way. But this is what a courtroom looks like. Let's just talk briefly about the different parts of the courtroom. So let me show you what we got. And I'm going to try to point with my cursor here. Are you able to see my cursor on your side? My mouse moving around? Okay, good deal.
Yes, I can. Yes.
Okay, perfect. So we're just going to go through just real quick and show you the different parts. Of course, up here, we have what we call the bench, and this is where the judge would sit. And you see this nice big judgely looking chair. So the judge is here presiding over the entire courtroom, right? Very formally. He's up a little bit higher because he is presiding. He's sort of the king of the courtroom, right? We have over here, you see this, it's almost like a gate, right? This partition that separates the public, which set back here in these seats. You can't see all of them, but there's lots of seats back here. So this partition separates the public from the actual courtroom itself. And what this is called is the bar. This is actually called the bar. You could call it the gate, but it's really the bar. And maybe you've heard of something called the bar exam that attorneys have to take and pass in order to practice law. And you may have heard it said that upon passing that exam, you are admitted to the bar. You're admitted to the bar. What that means literally is that you now have permission to go through this gate, to go through this door beyond the bar. You've been admitted to the bar to practice law. So you can go beyond the bar here. So that's where that comes from, this bar, right? Now inside of the courtroom itself, we have a couple of tables set up here on either side. These tables are for the defense and for the prosecution. Sort of depends on the type of hearing, but we'll call them that for our general purposes. And I can always tell which table belongs to the defense and which table belongs to the prosecution when I look at a courtroom. Even if I've never been there, I know automatically which one it is. And how can I do this? Does it have to do with the fact that one's on the left and one's on the right always? No, it doesn't. Each courtroom is different, and actually those things could switch. But even so, I can always tell which is the prosecution table and which is the defense table. And the way I can do that is that this table, which is the prosecution's table, is always the one that is closest to the jury. And so over here to the left, you can see a little bit of what's called the jury box, right? The section where the jury sits. And there's probably 6 or 7 seats here in here. Depends on the type of court that we're interpreting in, but there could be a jury of 6 people. There could be a jury of 12 people. And so it just depends a little bit. But the prosecution's table is always the one closest to that jury box because the prosecutors are the ones who have what's called the burden of proof. They have to prove to the jury in a trial setting that the defendant is guilty beyond a reasonable doubt. And since they have that burden of proof, and it's a very heavy, very weighty burden of proof, they're always situated closer to the jury so that they can more easily present that information. So if that's the prosecution's table over here, on this side then, we have the defense table. And so you would have probably a defense attorney and a defendant. And when we say defendant, of course, we're talking about the person charged with the crime. They would be sitting there. So those are the two tables, the two party tables that we have. Then we have up here, you see this auxiliary desk sort of sitting beside the judge's bench up here. This desk is most likely used for a clerk, for a deputy clerk. Clerks assist the judge with recording information and other administrative tasks as court is advancing, as court proceeds. And so if the judge makes a decision, if the judge issues some type of order, the clerk would record that information, would essentially write down that information and store the information in her computer system right here. A secretary could also potentially sit here, but more than likely this is for the clerk. And then up here on the left side of the judge's bench, you have a witness stand. And so you've probably seen on TV where somebody gets on the stand and they've got this big emotional testimony that they've got to give. Well, in this courtroom, this is where it happens, right here at the witness stand. Okay, so the witness would sit there, they would be sworn in, and they would give their testimony from that stand. And of course, you see that both of the tables for both sides would have pretty good access, pretty good line of sight to that witness stand to be able to ask some questions. Back here, let's go to this side first. You have this open door. It's nice and open and inviting. That is undoubtedly the door that leads to the judge's chambers. You never want to go in that door, all right? It looks inviting, but don't go in there, all right? That's where the judge works. And so if you were to go back there, you would have a separate office for the judge. There may be another office or two for a secretary, for a clerk. There'd be some files, and maybe there's a small library, something like that, right? So that's where the judge works. Again, don't go back there unless you're invited. And then on this side, though, you have this door that doesn't look nearly as inviting. In fact, it's got this big lock on it right here. This door is actually what we call the holdover cell. And so on a daily basis in court, of course, judges are interacting with, again, defendants, people charged with crimes. Some of those defendants are free and they are showing up in court of their own accord, right? They've been invited to participate, you might say, and so they're showing up. Other defendants, however, are not free. They are currently enjoying lodging at one of our county jails. And when that happens in the county in question, the authorities actually bring those defendants to the courthouse and they put them in this holdover cell. It's essentially like a jail, and they wait there until their case is called, and then they appear in person. Now, of course, with the COVID pandemic, it's a little different now. They're not transporting prisoners, defendants as often, and so usually it's done now by video, something like what we're using. But typically that's how it happens when we do in-person court, of course. Now, let's talk a little bit about where interpreters would stand. And it's going to vary, and we'll talk about this throughout our presentations. It's going to vary just a little bit. Normally, if we're doing a general district court docket, and we'll talk more about what district court is in a moment, but it's a docket where there's just lots of movement. There's lots of cases. District court is the people's court. So there's just, there's traffic tickets, and there's driving under the influence of alcohol, and there's fines. Pretty much anything that isn't extremely serious starts in district court, and the interpreter works in district court quite a lot just because there's a large volume of cases. If this were that type of docket, that type of session, right, there would probably be a podium right here in the middle of the courtroom, and the defendants would be coming up one by one to stand in front of that podium and to interact with the judge. More than likely, you as an interpreter would set up as well pretty close to that podium, right? You probably, in fact, would be standing beside the podium, and you would interpret as people would come up to the podium one by one. Again, we're talking about short proceedings, 2 or 3 minutes at most, very rapid turnover, and you may have several of those. And so you might sit down a moment, and then you get back up and you stand up, right? It's that kind of thing. Sometimes you would use interpreting equipment, headsets and transmitters. We'll talk more about that later. Sometimes you might just interpret out loud. It depends on the type of proceeding. But I could envision an interpreter being right in the middle, close to the podium, interpreting. If it's a more formal affair, something that's to last 10, 15, 30 minutes, an hour, more than likely the parties would be sitting, and you potentially would set up maybe very close to wherever the defendant is. So we talked about this being the defense table. So maybe you have the attorney here, maybe you have the defendant here, and normally you would maybe set up just to the side here. Again, you're probably using wireless interpreting equipment, so it's not as though you have to be right in the person's ear, but it's important to be fairly close, just to help with paralinguistics and to help manage the flow of information. So you might set up right over here somewhere. There's an extra chair over here. You'd probably pull that up a little bit. If there is an extra table somewhere, for example, if this table isn't being used, if there's no deputy clerk there, it could be a good idea to set up there as well. You sort of have to scope out how the courtroom is. I do try to avoid being so close to the defendant when possible. I mean, we'll talk more about why that is as we go through the training. But if you can get distance, I would recommend doing so. And if there's an auxiliary table not being used, or if it's a shorter proceeding and you don't mind standing, I might step away from the defendant. But realistically, you would be here either at the podium or probably somewhere near the defense table here. Imarta, have I forgotten anything as we've described the courtroom here?
Not that I can think of, no.
Perfect. We will come back to this in just a little while. When we get to skills building, we'll remind you of some things, and we'll talk a little bit more about where to stand and where to set up and all that kind of stuff. But for now, we've given you a good overview, of course. One more thing, actually, that I would mention. So this is the bar we talked about. This is the judge's bench, and then all the space in between those two things, all this floor, right? And sort of this big circle that's right here. We call that the well of the court, the well, okay? And it's important to recognize that you can't walk through the well of the court without permission. So let's say that as an interpreter, you're sort of admitted to bar as well. It's not exactly like an attorney, but you do have permission to cross the bar and to go in and to do your work as an officer of the court. So you're in there. And let's say for some reason you needed to hand something to the judge. You needed to grab something that was on the bench, right? There may be something that you're trying to get set up and get arranged before court even starts. Can I walk directly from here, directly up to the bench and grab it and come back to wherever I need to? I shouldn't. I want to be very careful with that. We can never walk through the well of the court without permission. So technically what I would need to do in that case, I start here and I would go all the way around behind these tables. I would go up and around, and then I would come up here and maybe grab it. And I would only actually do that if I had permission to do so. We want to be very respectful in court, of course. Now, sometimes in a proceeding, it is necessary for you to move from place to place. Maybe the acoustics are pretty bad where you're standing and you want to go someplace else. That's fine. Before you move, you want to say something like, Your Honor, may the interpreter move freely through the courtroom. Your Honor, may the interpreter move freely through the well of the courtroom. The judge will say, oh, yes, of course, just go wherever you need. All right, I've got permission. You wouldn't want to do that without that permission. In fact, if the judge is on the bench, court is in session, and you tried to walk up to the judge without permission, bad things could happen to you. There's bailiffs that's set up, throughout the courtroom. Bailiffs are a lot of times, they can be sheriffs. They work for the sheriff department. They're retired police officers sometimes. They're pretty tough guys. Sometimes you look at them and you're like, this guy can't do anything. Yeah, they can. They're tough guys. All right. He looks like he's sleeping. He's not asleep. He's going to jump up real quick. He's going to pop you on the head if you try to get close to that judge. So be careful with that. Don't go through the well of the courtroom, okay? And the bailiffs, by the way, would probably set up, here's a little table right here. I imagine that the bailiff would be back here, something like that. We'll talk more about that later. Let's move forward. We're on a roll here. So I'm going to turn it over to Imarta now to take us through a few slides regarding the Kentucky Judicial System and how everything is set up. Go ahead, Imarta.
Thank you, Joshua. Oh, and little bit of interesting information. In Florida, at least in the Ninth Circuit, there are no bailiffs in the courtroom. Everybody's actually a sheriff's deputy. They carry guns and everything. So they do not like being called bailiffs. So it just goes to show, to each his own. And everywhere you go, it's a little bit different. So I just wanted to tell people that, because who knows, some of the interested folks here may end up also going to Florida. And just know, at least when you go to the Ninth Circuit, do not call the sheriff deputies their bailiffs. They do not like it. They do carry guns, and they are not afraid to use them. Like Joshua said, do not get close to the judge. But back to serious stuff now. The Kentucky Judicial System has, as you can imagine, in any system, there is hierarchy, there are levels, and the higher you go, the more serious things are. We're going to talk about that a little bit between Joshua and I and give you some background. Keep in mind, though, that I am not admitted to practice law in Kentucky. So I couldn't really, even if we were there in person, answer questions about, for example, Kentucky law, because that would not be correct. But we're going to talk about these from the interpreter's point of view and give you a general idea of what it is like to be an interpreter in Kentucky and what the courts do at different levels. We have, of course, let's start from the bottom, because they're here in order of hierarchy, but the reality is things begin at the district court level, smaller crimes, which are called misdemeanors. Then you have the circuit court level, and family court is also part of the circuit court level. Then the Court of Appeals, and at the very top, number one, the Supreme Court of Kentucky. And we're going to get into details, I think, on the next slide, Joshua. So there we go. District court, as the court of limited jurisdiction, that means, as the name indicates, they cannot hear, which is the word that is used in English for that, hear all kinds of cases. There are 60 districts in Kentucky. And to be a judge at the district court level, the person must be an attorney that has at least 2 years of experience. That is an election process. The judge is elected to a 4-year term, and it doesn't matter which party the person belongs to. It is a nonpartisan ballot. The judges, of course, in district court are full-time judges. This is not something you can do part-time. You got to put in all your time and commitment. However, something interesting with district court in Kentucky is that they can conduct preliminary hearings in felony cases. A felony is a case that carries a penalty of higher than a year. Those are little terms that you will hear coming up throughout this presentation. And I believe at the end of this one, we have a slide that actually gives you a good list. Of course, once again, those of you that are already interpreters know all this stuff, but bear with us while we discuss it for those who are just beginning to take steps into this profession. Now, small cases, simpler things like traffic and non-traffic misdemeanors, those are heard at the district court level. Both civil and criminal cases are heard in district court. And in the case of civil cases, the amount of money that people are fighting over or in dispute doesn't exceed $5,000. And they also, the judges in district court also have authority to perform marriages. By the way, you may be called as an interpreter. I know I have. I don't know if you have, Joshua, being called to a wedding ceremony in district court in Jefferson County. It's actually nice because a lot of what we do is difficult. People that come to court are hardly ever happy people, but unless you're adopting a child or getting married. So it's one of the enjoyable things or happy, joyful moments for people that come to court. And as an interpreter, you may be called to be part of that. I really enjoyed that. Can you show me the next slide? Thank you.
Absolutely.
Yeah, for a court of limited jurisdiction, the reality is that district court does have a lot of things to do. District court judges are busy. Uncontested probate matters are also heard in district court. And what that means, a probate matter deals with the distribution of a person's estate upon death. And uncontested means that nobody's fighting the will if there was a will. Everybody's in agreement as to how things should be distributed. So then we have guardianship and conservatorship for disabled people. Who's going to be the guardian of this person? Who's going to be in charge of administering their affairs and their property? Those are delicate matters, and those are heard at the district court level. Disability determinations, administrative actions, name changes. So if you want to change your name, you do it in district court. Forcible detainers and evictions. Forcible detainers is basically a fancy way of saying an eviction action, an action between landlord and tenant, and also small claims courts of less than $2,500. Now, again, except for family court, which is at the circuit court level, we were saying before, both district and circuit court hear both criminal and civil matters. The criminal cases begin in district court, and they are misdemeanors, violations, except if the charge is together with an indictment or felony. A misdemeanor is a case that doesn't take a penalty higher than a year. So that's where the case would begin in district court. But if it is joined with a felony case, then it may be different. Now, felony may begin by itself in district court, but once they have a preliminary hearing or the grand jury indicts the person, it is going to move out of district court. Your traffic tickets, if you've had those, you know you're going to be appearing in front of a district court judge. Ordinance or code violations, those are related to cities and counties. Those are the rules that cities and counties establish for the operation of the people that leave the rules to live by within that jurisdiction. And preliminary hearings and jury trials. Yes, there are jury trials in district court. Those evictions could be with a jury. Those simple matters in civil where people are fighting over $2,500 or up to $2,500, those happen in district court. And some traffic cases also. I've had very simple traffic cases that for some reason or another ended up in front of a jury. Now, interestingly enough, there are counties that don't have a family court established just yet. And in those places, domestic violence cases go before the district court. Cases involving child abuse and neglect, and juvenile cases, which are closed confidential proceedings. You can imagine the reasons, you don't want to mark a child forever just because they made a mistake. So normally the United States is an open court system unless things are very, very delicate, as a juvenile case is, or a case involving a child. And in those situations, then only the parties involved in the proceeding, the prosecution, the defense, the parents, a witness, a child advocate, and you as an interpreter will be there. The door is closed, nobody else is allowed in, just the people that are strictly necessary for the proceedings to go on. Status offenses are crimes committed by juveniles in criminal cases.
Thank you, Armada. Let's go through now circuit court and some of the other courts we deal with. One thing that I did want to mention that occurred to me as Armada was speaking, we talked about taking notes throughout these presentations. This presentation specifically would lend itself very well to glossary building. So perhaps if you have something to take a note with, now would be a good time to start writing down some of these terms that we're throwing around and making sure that you understand exactly what those concepts mean. So we've already talked about felonies and misdemeanors. What are those things? Write them down. A felony is any crime that can be punished by from 1 year in prison all the way up to the life, right? all the way up to a life sentence or even the death penalty, which does exist in Kentucky. That's a felony. Misdemeanor, however, is anything punishable by up to 364 days in a county jail. Make sure you understand the distinctions. Those distinctions will help you ultimately interpret, because you can't interpret what you don't really understand. You got to know a little bit about everything. So glossaries, take notes. We just talked about district court. As you may have understood just from going through all the things district courts do, it's a very busy place. Lots of volume in any county, and we have 120 counties in Kentucky. In any county in Kentucky, the busiest court is going to be that district court for that county. Because of that, by default, you end up working there a lot. So it's important for you to understand what's going on. Let's talk a little bit now about the next up court, circuit court. So although there are 60 districts in Kentucky, there are only 57 circuits in Kentucky, which means some of those districts are combined to form, a larger circuit. You may have one circuit judge that actually oversees a few different counties. That happens in a couple of cases in Kentucky at least. In this case, for circuit court, judges must be an attorney with at least 8 years of experience. So you go from 2 years for district court and then 8 years for circuit court. There's quite a big difference there in terms of experience. They actually tried to update the law recently and make it so that district judges had to have 8 years of experience as well, and that law did not pass. And so district judges 2, circuit judges 8. I don't know. I would prefer my judge to have a little more than 2 years. That's just me, but I'm just saying. They are elected to 8-year terms. District court was 4 years, so these are 8-year terms, nonpartisan ballots, which means that they don't run as Republicans or Democrats. They do campaigns, of course, but they don't run based on a political platform. At least they shouldn't. They will handle in circuit court civil actions over $5,000. Remember, if it's under $5,000, it ends up in district court, of course. If it's bigger than that, we're talking big money, it's got to go to circuit court, got to go to the big judge. They handle felonies or capital offenses. Remember, we talked about felonies just now. Felony is a crime for which you could receive a punishment of at least 1 year in a state prison, up to a life sentence or the death penalty, right? And that's exactly what capital offenses are. Capital offense, a capital crime, indicates that the death penalty is a possibility. I, as an interpreter, have interpreted in cases in which the death penalty was on the table. In fact, I can remember a couple of cases in which there was heavy debate as to whether to sentence the defendant to death or not. I've never interpreted in a case in which the death penalty was actually given as the sentence. It was always decided not to give the death penalty. It's very rare that that happens, of course, but I have interpreted cases where that was a possibility. They also handle dissolution of marriage, adoption, termination of parental rights, and specifically that's in that family court division that we talked about. As Marta mentioned, not every county has a family court. If they do not have a family court, then the district court judge takes care of these things. If there is a separate family court in that county, then it's technically part of circuit court. And family court judges are actually circuit judges. Sometimes we forget that, but keep in mind when you're in front of a family court judge, that is a very high-ranking judge within our judicial system, and that judge has the same authority as an actual circuit court judge. They also handle contested will probate. So when someone dies, they have a will that has to be legalized, you might say. They have to go in front of the court. It goes through probate, which just essentially says that they formalize that will and a judge approves that will for distribution of the assets, right, for division of the assets. When there is contestation, when all parties are not in agreement, right, family members are fighting each other for who gets what. I want Aunt Clara's silverware set. You can't have it. Okay, well, what's going to happen? We got to go in front of circuit court and they have to decide. So these judges will make those decisions. They also handle appeals on the record from district court. And so what that means is that in Kentucky, every court level that you can interact with, there's always a right to an automatic appeal to the next highest court level. So if you end up in district court, you can always appeal the decision of that district court judge to the circuit court judge. Always, you have that right. Right now, they may not rule in your favor, but you can appeal. If you're in circuit court, they have to appeal to the next highest court as well. And we'll talk about that in a moment. But these judges, these circuit court judges, they handle appeals from district court, and it happens quite frequently, I would think. And then, of course, just like in district court, circuit judges do jury trials. In fact, when we do interpret for jury trials, normally it's in circuit court, I would say. It's a little bit less frequent that they happen in district court. Most things will resolve before it gets to the trial in district court. In circuit court, however, things go to trial quite frequently. And most of the time when you find yourself in a trial in Kentucky, it'll be in circuit court, and trials are exhilarating. It's a lot of fun. We'll talk more about those later. They also do reviews of administrative agency final orders. And so this is sort of like an appeal as well. If there is, if some state agency issues some type of definitive order, definitive resolution regarding some conflict that they've been involved in, right? They sort of just unilaterally decide, okay, this is our decision, this is what we're going to do. Well, essentially, parties that participate in that process can appeal to circuit court, and the circuit judge can also review those administrative agency final orders as well, and then make a decision. It's essentially like an appeal. It's just called a review, but that's what that is. All right, let's talk about family court. As we just mentioned, family court is a division of circuit court. They hear cases involving families and children. I can tell you that most of the time when you talk to interpreters, they will tell you they don't like to interpret in family court too much. It does vary a little bit, but most interpreters will tell you, oh, I hate family court. I'm sort of an exception. I actually really like family court. Most of the time interpreters tell you, well, I don't like family court because it's contentious and it's ugly family stuff and child abuse. I don't like those things either. Most of the things in family court that we interpret deal with domestic violence cases, and you have two parties that are accusing each other, usually of misconduct, actual domestic violence. I like interpreting those just because the material you're working with when you interpret is fantastic. You get to talk about all the he said, she said. You get to hear some crazy words. You always have to curse in those proceedings. We'll talk more about that later, but stuff comes up that you normally don't get in other proceedings. So I don't mind family court, but it can be very taxing. So I understand why people don't like it. Okay, let's talk about the jurisdiction of family court judges. So these are all the things that they have authority over. Dissolution of marriage, which actually means divorce, of course. Now, I do agree with my colleagues. I don't like interpreting divorces. They're very contentious. I try to avoid that if I can. Sometimes you can't, but I try to avoid it. If I can, I assign that to somebody else, right? It's good to get that experience too, but I'd like to not be the person in there. Just it like gets on you. You feel it. It's a weight on you. You want to get out of there. Spousal support and equitable distribution. So, child support, alimony. We do that quite a bit, especially child support. I mean, as it says next, child support and visitation. So coming up with a visitation schedule between the parties, we do that quite a bit. Paternity, paternity testing, DNA testing, things like that. Adoption, as I might have said, sometimes we get lucky and we get to do happy things. So you have weddings, and adoptions are another case usually of happy things. You don't get to interpret them very often, but it's very uplifting to do one of those. The kids are very happy, the parents are very happy. It's a great day. We don't get that often, and so that's a lot of fun. Domestic violence, as I just mentioned, I don't mind domestic violence cases. I get all kinds of good terminology from those. You do have to be ready to go in those cases because it can get a little bit ugly, but I find those to be interesting. Dependency, neglect, and abuse, or we call those DNA cases. And I'm not talking about physiological DNA. I'm talking about dependency, neglect, and abuse. And that goes hand in hand with termination of parental rights. So what you have is an allegation of child abuse or child neglect, and that can lead to termination of parental rights. And so there's an actual court proceeding to determine if this child will be taken away forever from those parents. That can be really hard to interpret for. Probably the thing that I least like to interpret would be cases related to child abuse. I mentioned before I had 4 kids. When I'm in those cases, sometimes it's very hard for me to hear those things. This is important for ethics, which we'll talk about later. Even though I don't like it, I can do it. I can maintain my impartiality, and I can certainly be professional interpreting that. I know about myself that I prefer not to be in those settings, and so I try to avoid it. But if that's what the job entails, I certainly can do it, and I've done it many, many times. I've interpreted some of the ugliest things that you can imagine in federal court in Miami. Very ugly things related to this, things that nobody should really ever have to hear. I can do it, don't enjoy it. Keep that in mind. Where we interpret, it's not all traffic tickets. All right, you have to be aware of what you're getting into. They also do cases related to runaways and truancy. So a teenager or maybe somebody even younger runs away from home, or they're what we call out of control, an out of control teen. Truancy means they're not going to school. Family courts deal with that, and they put orders in place and conditions in place to make sure that those kids go to school. I might have mentioned something earlier called a status offense. Going to school in and of itself wouldn't be a crime. Not going to school wouldn't be a crime, except for the fact that the person not going to school is a minor. And so a status offense is, like she said, it's a crime committed by a minor that wouldn't really be a crime if not for the fact that that person is a minor. They don't have a choice. They have to go to school until they're a certain age. So that's what this really entails. Let's talk about Court of Appeals real quick, which is really what we might term an intermediate appeal court. And so remember how we said that there's always the right to one level of appeal, no matter what court you're in. So if you're in district court, you automatically have the right to appeal to circuit court if you don't like the district court judge's decision. Well, if you're in circuit court, you automatically have the right to appeal to the Court of Appeals if you don't like the circuit judge's decision. Doesn't mean that they will agree with you, all right, but they do have to hear it and they have to review what happened in the case to see if the judge maybe made some type of procedural or legal error in the decision. And then they either side with the initial ruling or they may side with you and they may overturn the initial ruling and you go back to court and you do it again. So that's what this court is. This court consists of 14 judges, and we're talking about judges all across the state. So there are appeals judges assigned to those circuits that we talked about before. The judge must be an attorney with at least 8 years of experience. It is an elected position, and they're 8-year terms again. And so you get some turnover here, as you do with all judges. Appeals court judges are not, they're not lifetime appointments, right? They're every 8 years, they turn over. Their primary function is to hear appeals from the circuit court, including the family court division. So that's what they spend most of their time doing. There are some things that they don't have to hear. They can decide sometimes, you can always appeal to circuit to the Court of Appeals, but you may not have that right unless it falls in those categories we talked about before. You have an automatic appeal. So sometimes they can decide to hear something or not, but most of the time they have to. And so they stay very busy doing that. Last but not least, let's talk about the Supreme Court, which is our court of last resort. This is a step up from the appeals court. We have 7 justices, so we no longer call them judges, they are justices. We have a chief justice and then 6 justices, 6 additional justices. Again, they are all attorneys with at least 8 years of experience. They're 8-year terms, they're not lifetime appointments. I can tell you this, I think in lots of states, the Supreme Court seems like this shapeless entity that's just out there that you don't know who they are, you don't really know what they're doing, you never interact with them. It's just beyond all control. I am so happy to be able to tell you that our Supreme Court is so involved in what we do every day on an operational level. They've especially shown excellent leadership throughout the pandemic. I know who they are. They send emails. They respond. You can interact with them. They're just real people, real good people, I may say. And they're just trying to do good work out there. So we're very fortunate in Kentucky. They're excellent, really excellent. Let's talk about their jurisdiction. They mostly handle appeals from the Court of Appeals, right? And keep in mind, this is a discretionary review of Court of Appeals decisions because you only have right to one level of review. So if you're in district court, you go to circuit. But let's say you're in district court and you appeal to circuit, and that circuit court, let's say that they don't like, they deny your appeal, right? They agree with the original judge. Well, you can appeal to the Court of Appeals, but that is a discretionary review. The Court of Appeals can handle it or not. But let's say they do. Let's say that they consider it. Okay, I consider it. And let's say they also agree with the original judge, the district court judge. And you say, I'm going to take it to the Supreme Court. So you appeal up to the Supreme Court, right? It goes up to the Supreme Court. Again, it's discretionary review. They don't have to hear it, and they most likely will not hear it. Typically, they don't take cases, especially one that has already been denied twice on appeal, right? Motions to transfer from courts of appeals for cases of public or great general interest. Usually that's what they'll hear. So if something goes to the Court of Appeals, and let's say the petitioner, the person that appeals, the appellant, doesn't receive the decision that he or she would like, they can appeal to the Supreme Court. That appeal to the Supreme Court is considered, and normally they would only hear things of great public interest or great general interest. Off the top of my head, in the past few years, we could talk about something related to firearms, something related to, gender equality, um, same-sex marriage, that came up, the death penalty, things like this, things of great interest, great public interest would probably be what they would hear. They deny a lot of appeals, or you could say that they opt not to review a lot of appeals from the appeals court just because they don't have to, and they're very busy. They do have to review, however, direct appeals from circuit court if it's regarding a judgment of death or a life sentence or imprisonment for 20 years. So automatically they can skip, in those cases, you can skip the Court of Appeals. You can go directly to the Supreme Court if it has to do with one of those things. Again, very important things, right? Again, they stay quite busy. I've actually had the good fortune to present to the Supreme Court on some administrative things that we've had to do in our department. Fantastic, fantastic people. Really, really great, just great group of people. Really, really excellent leadership. Let me turn it back over to Imarda now, who's going to take us through court procedure. Now, what actually happens in these courts, how a case flows, how a criminal case starts, for example. Imarda, go ahead.
Okay, so based on everything we have been talking about so far and how busy the courts are, where do you think you will be in the most? Which court level? Normally, we'll be taking a show of hands, but if you answer district court, you are right. Because there is a lot of work going on, and because we would never set you loose to swim or sink on your own at a circuit court level or at a family court level where there are so many things going on and so many participants and so many acronyms, which is something else we will talk about at some point here in this orientation. You will be a lot, and we are a lot, actually, in district court, handling misdemeanors and learning the ropes before you do anything else. So when the judge comes in, you always show respect by standing up. The institution of the court, like it says here in the presentation, you may not like the judge as a person, you may not respect the judge, but that person at that time has a level of authority that you have to respect. So the appropriate thing to do is to get up, and then when you receive permission from the judge, you sit back down. It is, as the presentation says, an artificially formal place. So there is a decorum, a type of behavior that is expected. And also you get up for the jury. When there is a jury trial, every time the jury comes in and out of the courtroom, everybody gets up, including the judge. In that case, it's a way of showing appreciation for the service that these folks, members of the community, are doing, their civil duty. So even the judge gets up for the jury as they come in and out. Okay, so here we have key players in the system, as you can imagine. The judge, of course, who is the presiding person, the highest authority, and then the judge's secretary, who may or may not be in the courtroom, like Joshua says. Generally, there will be a clerk, a courtroom clerk that is part of the judge's staff, but the secretary per se, or judicial assistant, which is the other term, will stay in the judge's chamber or in the judge's office, and sometimes they come in and out as needed if they have to give the judge a message or things of that sort. The bailiff, who keeps order in the courtroom, a pretrial officer, we'll talk about that maybe a little bit later. These are people who do investigations and processes for defendants in certain matters. And as an interpreter, sometimes you will interact with them a little bit. We'll discuss that when we get to certain matters of ethics and professional responsibility. There's the clerk of the court and the deputy clerks. There is in every county a clerk who is the highest authority, and they delegate authority to those deputy clerks that you see in the courtroom when you are there, and at the windows when you go to the court house to do things, not necessarily in a courtroom per se, not before the judge, but those folks that are behind the windows, a lot of times they are, deputy clerks. The court reporters, We don't have them in Kentucky. A few years ago, they went to a whole electronic system of recording audio and video. But in a lot of states, they still have court reporters that take down the proceedings, stenographers, and they do that for the purpose of keeping the record. Because as we were saying before, if a party is not happy with the decision, be it the judges or the jury, they're going to appeal. And for that, you need a record, an accurate record of what was said, what happened during the proceedings, and the court reporter takes that record down. Then you have your probation and parole officers, your defense attorneys, and your prosecuting attorneys. Of course, prosecuting attorneys is essentially the county attorney, which is called here. And in the case of civil cases, you have the defense attorney and the plaintiff's attorney. So let's talk about the way in which a criminal case begins. A law enforcement officer, a police officer, can see you committing a traffic violation and they can give you a traffic ticket. Or they can give you a citation because you committed a misdemeanor, such as stealing in a store. Let's say they saw you, or the store owner saw you, and they call the police in. They don't arrest you, but rather they give you a citation, and it has a date to appear in court and answer because of that. Or the law enforcement officer could actually arrest you. In that case, they will put you in the county jail until you go before a judge to read you the charges formally, and there is a whole other proceeding after that. You could receive a summons, which is a formal citation issued by a judge. There could be, a summons is not issued by a judge. You could just receive a summons, a formal citation. What is signed by a judge is an arrest warrant. An affidavit has to be filed by the police officer or the detective that has been conducting an investigation. So when they have enough information that warrants an arrest warrant or a search warrant, they'll go before a judge that will review that, and based on that affidavit, they will sign the warrant, and that's when the police shows up at your house or your place of work, depending on what is specified, to either simply arrest you and search the premises, or one or the other. So in circuit court, there is an indictment by a grand jury. Grand jury is presented with information by the prosecutor, and they decide if there is enough to charge the person with this crime that is a felony. It's no longer a misdemeanor. It's the serious stuff that can put the person in jail longer than a year. Or it could be an information, which is simply another way of calling this document, this formal charge against a person, a defendant, but that is not coming from the grand jury. Now, be careful with the word information when it is first thrown out, because your instinct is to think of it in the sense of knowledge that people have, so when you're interpreting that word, you need to have the background, a little bit of context to know if they are referring to general knowledge about things or this document that is going to inform the defendant. And that's my understanding of where the name comes from, informing the defendant of what the charges are against him or her. Now, jurisdiction in all criminal cases in circuit court has to be either by indictment, which is very formal with the grand jury, or information, which is a little bit less formal. But as you can see, and we talked about that a little bit earlier, the majority of felony cases actually begin in district court, begin at the lower level, and eventually they get sent to the grand jury to make a more formal decision. So in district court, there is an arraignment. That's the first appearance by the defendant, and that's where the judge is going to read the charges formally or tell the person what they are accused of. And at that point, the judge evaluates the need for an interpreter. That's when the judge realizes this person doesn't speak English or is not proficient. It's better to have an interpreter. The sooner they realize it, the better. At that point, we would be called in. And that's where we start to be one of those key players, sort of, or be involved in the process. Bail, which is the money to let the person out or not. And the court decides if this person needs a public defender or not, based on then obviously in criminal cases in the United States, as you know, a person is entitled to have a defense lawyer, and if they cannot afford it, the court appoints a person. So the judge will ask the person certain questions about how much money they make, what their expenses are, and based on that, they will decide if they will appoint a public defender. So in district court, while still in district court, if the charge is a misdemeanor, you know, the not so serious type of crime or a violation or a traffic ticket, the court is going to ask the defendant to enter a plea of guilty, not guilty, or no contest, which is called an Alford plea in Kentucky because it comes from a case where the defendant's name or one of the parties' name was Alford, and it comes from that. Would you know, Joshua, if Alford was the defendant? It had to be.
Yes, it was. I believe it's Alford versus North Carolina, I believe.
Okay. I honestly don't remember if it, but
yes,
we don't call it that in Florida. It's just a guilty plea. In general, we used not a specific case name. It may just be something lost in the system, doesn't have a specific name.
For a long time, I thought that it was something that was specific to Kentucky, but I found out that other states have Alford pleas as well. And so, Alford was the name of the defendant that challenged and apparently took it to the Supreme Court ultimately. And there was a decision that now allows people to plead guilty, but using an Alford plea. So it's exactly what I might have said. I mean, they're not exactly admitting guilt, but they're recognizing there's enough evidence against them for them to be found guilty. And so for all practical purposes, it's a guilty plea. They're just they're avoiding saying, I did it, basically.
Right. And maybe this is, not sure if this is the right time to talk about this a little bit, but I'm going to insert it. It's a term that, as far as I know, causes a little bit of difficulty for interpreters to interpret because it is such an unusual concept in other places, but we have it in the United States. So it's something for you to think about in your language about what would be the best way to interpret this term to convey it to the person who needs an interpreter. So let's see, the court will often ask for a plea or sentencing recommendation from the county attorney, the prosecutor. So yes, you're there. You're the defendant. There is the prosecutor. There is the judge. Sometimes the prosecutor has an offer to make or recommend a sentence. And at that point, in front of the judge, they make the offer. If the defendant can accept it or not. If the defendant is appearing pro se, meaning they do not have an attorney, they make the decision. If they have an attorney, they could take some time to talk to the attorney about it, or right there, the attorney says, it's okay, I think it's a good deal, you should accept it. If the defendant pleads guilty or no contest, the court will probably impose a sentence right there. If the defendant pleads not guilty, then the case is continued, which means it just gets moving on to another date. They can schedule what is called a pre-trial conference. In a lot of cases, there will be that first appearance where you get informed of the charges, the prosecution makes an offer, and either the defendant doesn't have a lawyer or the lawyer says, let me talk to my client a little bit about it. I need to find out a little bit more. Or in some cases of driving under the influence, they want to see the video from the officer's body camera. They want to see the results of the blood work. And it's okay, let me get this information first. Let me talk to my client, and then we'll make a decision. And at that pre-trial conference, when they come back, they are ready to say, okay, it's a good deal. Let's accept this offer from the prosecution, and the defendant then pleads guilty or no contest. Now, if this case, this felony, this heavy duty crime that began in district court, the defendant cannot enter a plea there, even though it began in district court, unless the prosecutor is willing to amend it or modify it and bring it down to a misdemeanor, because the judge in district court cannot accept a plea for a felony. But sometimes it happens that after reviewing the facts or discussions with the defense lawyer, the prosecutor realizes that it is okay, for whatever reason, it's within their authority to amend the case, modify it down to a misdemeanor. Or the case can be set for a preliminary hearing. At that preliminary hearing, when the parties ask questions and present a little bit more proof and information, the case can be discharged or dismissed because there is no probable cause. Again, the prosecutor can amend it after hearing more evidence from their witnesses, or it can be sent to the grand jury after the judge has determined that there is probable cause.
So let's talk a little bit then about some key legal terms to sort of supplement the information that we've received. Before we get there, however, it just occurred to me that in building your glossaries and in going through the presentation that we just gave, both Armada and I have spoken a lot about legal concepts, have described how things flow through our judicial system. It would be a fantastic tool for you to go back and listen to this, watch this video again, listen to the recording again, and while you're listening to it, try to interpret simultaneously out loud. So as you hear Armada talking about her, about the way that information flows, what happens in district court, for example, she's using lots of different terms, describing lots of different concepts. Those concepts are things that come up in court frequently. In fact, they probably represent the very foundation of what you need to know. Same thing when I'm speaking, you know, I've talked about different things and how it happens. Go back, listen to this again from the beginning, simultaneously interpret it as you go. Can you keep up? If not, where did you get hung up? And if you got hung up on a term, look it up and try again. All right. So let's talk about some of the terms that we've identified so far. Just going to make sure we're all on the same page here. Bail bond. Sometimes you'll hear it just called bail, or sometimes you'll just hear it called bond, but it's bail bond. And as Armada said, it's referring to an amount of money or perhaps property that can be deposited as a guarantee for somebody to appear in court if that person is released from custody. So somebody's arrested, the judge says, yeah, I'll let you out, but I'm only going to give you a $500 bond, $500 bail. That means if that person deposits $500 with the court, that person can get out. Now, there are conditions, right? So the condition is you got to come back to court. You can't get in any more trouble. The judge will set all these conditions. The thing is that most people don't understand about bail bond is that you get that money back. Assuming that you fulfill all of the conditions, you will actually receive that money back. Now, if you don't fulfill those conditions, you lose that money. And so that's the incentive to come back. And they can be lots of different things. It could be property, it could be your house, it could be your friend or your family member's house, it could be your mama's house. So let's say that your mama puts up her house as collateral for your bail bond. And if you don't follow the conditions, what can happen? They take your mama's house. So don't let them take your mom's house. You got to come back to court, right? So that's the incentive, obviously. That's important. Arraignment, we talked a little bit about this. It's that first interaction that a defendant will have with a judge. They give the rights. They formally inform the defendant of the charges. Jurisdiction can be thought of as the authority that the court has over certain matters. And jurisdiction varies based on the level of court, district court, circuit court, family court, right? Indictment is a fancy word for for formal accusation, and an indictment comes from the grand jury. And it's funny because I've interpreted for the grand jury. At times as interpreters, we're called to do that. And people think it's this really formal, secretive thing, the grand jury, what do they do there? And it is confidential, don't get me wrong. But every time I've gone, and I've done this quite a few times, you go in and there are people from the community that they picked for jury service, it's grand jury service, and they're, sitting along the wall, and the prosecutor's presenting information, and every one of these people is eating, a piece of pizza, right? Every one of them has a piece of pizza, and they're gnawing on the pizza like, yeah, based on that, I think he did it. Yeah, let's do the indictment. I vote to indict, right? There's really nothing, secretive about it. It's just they're confidential, but you may have to interpret there as well. A warrant, of course, you can have an arrest warrant. You can have a search warrant. It's a document signed by a judge that gives authority to do something, again, usually arrest or a search. Public defender, it's a free attorney given to someone who is what we call indigent, right, poor. Sometimes there's a special document or affidavit that somebody has to fill out to prove, in fact, that they are poor and they would qualify for a public defender. It's a misconception many times when you talk to defendants, and maybe specifically this relates to defendants with limited English proficiency, because I think it's a cultural disconnect here. Sometimes the judge will ask, sir, do you have money to hire your own attorney, or would you like a public defender? And a lot of times they will say, oh no, I don't want a public defender, I want a real attorney. I'll get my own attorney, I want a real attorney. And it's not understood that public defenders are not only real attorneys, but they're excellent attorneys. Usually they're the best attorneys because they just have so much experience. They do this all day, every day. They have a huge caseload. A lot of times attorneys will do this starting off in their career to get good experience. My personal experience has been that public defenders provide excellent services. So keep that in mind. They are real attorneys. They have all the same qualifications and they specialize in exactly this thing. Unfortunately, not everybody understands that. There's the plea. So the plea can be, a plea of not guilty or a plea of guilty. It's a formal declaration, a formal statement of guilt or innocence, perhaps. Sometimes we talk about a plea deal. That's when you negotiate the sentence, and then you decide if you'll plead guilty or not guilty based on this negotiated deal, the plea deal. Felony, we talked about that. Remember, over 1 year in a state prison, up to life in prison, or up to the death penalty. Misdemeanor, it's lower, so it's up to 364 days in a county jail, and it could just be a fine. There may not even be any jail time involved at all. Violation is like a traffic ticket, speeding. So it's not qualified as or classified as a misdemeanor or felony. There's no jail time associated. We're just talking about fines and other administrative consequences. You could lose your license or something like that. Court cost. So anytime you go to court, almost for any reason, you're charged an administrative fee. And usually it's like $134, $154. It's something like that. And that is the money that the courts use to operate. And so if you go to court and you're charged with something, even if it's dismissed, or even if you get a really good deal, you probably have to pay court costs. They can be waived. That's another glossary term. Waived if you are found to be indigent. If you can't pay for them, you could ask the judge to waive them, maybe not pay, but most of the time they are charged. Restitution is another type of money. This is to compensate for something that you broke. These are to compensate for losses that occurred due to your actions. So maybe it was your fault, there was a car accident, and the other person's car was damaged and it cost them $500 to fix. You had to pay restitution of $500 to make them whole, to make up for the damage that you caused. Restitution is something that's pretty common, and especially in district court, you'll hear that term quite a bit. Sustained and overruled, these are terms that judges use frequently. If somebody objects, if an attorney objects, Your Honor, objection. It's not accurate. Your Honor, objection. Leading the witness. Your Honor, objection. Badgering the witness. Objection. Asked and answered. There are all these different reasons why attorneys object to something. The judge will consider it, and they will either sustain the objection, that means they agree, or they overrule the objection, means they don't agree. Make sure you know how to say that in your language. Look it up, part of your glossary. A fine is just another administrative fee, another type of administrative fee that you have to pay for committing certain crimes. If you have commit DUI, driving under the influence of alcohol, there are always big fines associated. because it's supposed to hurt a little, right? They don't want you to do it again. You may not remember going to court, but you remember paying that $500. Speaking of DUI, let's talk about it a little bit. You'll hear it phrased in different ways, and you'll see different acronyms. So driving under the influence of alcohol or drugs, that's technically what it is. And we just say DUI, DUI. But it could be other things as well. You may hear DWI, which is driving while intoxicated, OVI, operating a vehicle while intoxicated, OMVI, operating a motor vehicle while intoxicated. You can figure it out, the rest of these. Make sure that your interpretation reflects the terminology being used, all right? Now, if they say DUI, and we'll talk more about this when we get to ethics, can you just in your language say the letters DUI? Well, it would depend on if that has any inherent meaning for the listener or not, right? Some acronyms in English would. If I say FBI, maybe FBI, if I say that in my second language, which is Spanish, probably pretty understandable. If I say DUI to somebody, even if that person's been here a long time, they probably don't know what that means. So if they say DUI, you probably got to say driving under the influence of drugs or alcohol, right? Probation and revocation, conditional discharge, and parole. I want to put these together. These are separate things. People use these interchangeably, but these are separate things. Make sure you know what they are. So as homework, I want you to look this up on your own. Make sure you know what it is. Probation happens instead of going to jail. They give you probation. So it's a type of conditional freedom. There are conditions. You cannot go to jail, but you got to do this or you have to avoid doing this. Revocation means you were on probation and you messed up, and they revoked your probation and they sent you to jail. That means they took away your probation, they ended it, and they sent you to jail. Conditional discharge, it's more general. Probation is a type of conditional discharge, as is parole. It just means that you're free with conditions. And then we have parole. Parole means you went to jail and they let you out early, maybe for good behavior, but there are conditions along with that. Make sure you have words in your language to accurately represent all of these. They're not interchangeable. Sometimes we use them that way, and that's not true, especially probation and parole. Understand the difference and make sure that you have good interpretations of each, accurate interpretations of each. And then, of course, we have probation and parole officers. They're the administrative officials in charge of ensuring that people follow the conditions of probation and parole. They are law enforcement officers as well. They carry weapons, they carry guns. All right, ladies and gentlemen, that concludes today's presentation. As Marta and I told you guys at the beginning of this, we want to encourage you to contact us. Here is our contact information. This is our work email, joshuaelliott@kycourts.net. Amaraliste Gonzalez at kycourts.net, exactly like that. You'll get to the right place. Feel free to send the email to both of us. You'll probably get a quicker response because one of us is busy, the other one will respond. And she and I may interact a little bit. So that concludes today's presentation. Marta, any last words for the kids before we're finished for the day?
No, just thank you for your attention. This is indeed very necessary for what we do. It's a little bit dry, but I think we can promise you that the rest of the stuff we're going to do is a lot more fun. But this is one of those that you cannot do without. Even if you were an interpreter someplace else, it helps to take a look at how we do in Kentucky and give you that background information. And for those that are just getting their feet wet into this, you will definitely need this information and those key terms that you need to look into, like Joshua said. Look it up, get familiar with them, get a feel for what things are like.
Very nice. And yeah, Marta has a good point. We used to do this presentation sort of at the end of our orientation, after we've gone through all the other fun stuff, and people are just falling asleep on us. So now we put it at the beginning when you're fresh, all right, so we can go through it. So this was video 1. We'll see you next time in the next video. We'll be in touch, guys. Take care.